Unfortunately, we've been doing this now for about 14 months, and most of them go pretty smoothly, but once in a while we get a little hiccup, and the server wasn't letting us, it kind of booted us out of the system. So for the benefit of the 150 or so people who are on the phone listening in, that wouldn't be too fair to them, so thanks for your patience. Just to let you know, this program is being recorded. Welcome to our program today entitled 10 Best Practices for Protecting Your Nonprofit's Intellectual Property. My name is Jeff Tenenbaum, Chair of the Nonprofit Organizations Practice here at the Venable Law Firm. And as many of you know, because I've seen many of you month after month, this is part of a monthly series of nonprofit legal seminars that we do here in our Venable's DC office every month with a webinar component for those in DC and across the country who are unable to join us in person. We do these from 12:30 to 2 p.m. Eastern Time once a month. And for those of you who can join us, we always offer a complimentary lunch here in D.C. And thanks to the great crowd we have here in D.C. for joining us today. Now, we have a really interesting program today. And I know from the very large registration list that we have that it's certainly a topic of great interest. And it's a topic, frankly, of great interest to us and to me. This is an area in which we do an extensive amount of work for hundreds of nonprofit organizations each year. And it's an area of law that really cuts across lots of other areas of law. It's an area of law that cuts across lots of programs and activities of nonprofit organizations. I saw from the registration list that we have a really diverse array of folks joining us in person and on the phone from lots of different departments within nonprofits, and that's not surprising based on the topic. We're very fortunate to have with us two terrific partners of mine at Venable, with whom I've worked for many years very closely, and both of whom have worked with hundreds and hundreds of nonprofits each year in connection with intellectual property and other related issues. Andrew Price to my immediate right and A.J. Zatola to my far right. Andrew is an absolutely phenomenal trademark lawyer who has been our primary go-to person when it comes to trademark protection and trademark enforcement and everything relating to trademarks for many, many years now. He's absolutely phenomenal at what he does. You're going to learn a lot from him today when it comes to trademarks. There's some slides here that talk about kind of the background of our trademark practice and also kind of our technology transactions practice and copyright practice and all the hodgepodge of things that AJ works on. So we're not going to focus on that today during our program, but you can take a look at the slides if you want to see some more background about our practice in that area. AJ Zatola, I've also worked with for many, many years. Started working with AJ in connection with technology transactions, software licensing contracts, web hosting contracts. AJ has a really strong technology background, but he's also a terrific IP lawyer, particularly with respect to copyrights and trademarks, and he's really also evolved into our kind of go-to guru when it comes to social media-related legal issues. And all of these things, as you're going to see today, really intersect in the nonprofit world. And both AJ and Andrew, you're going to be very fortunate to hear from today. AJ, if you can go back to the slide about upcoming programs as well. As you know, this is part of our monthly seminar series. I wanted to talk to you about our two upcoming scheduled programs that we have next month on July 12th, same time, 12 to 2 p.m. Eastern Time. The program is being titled Nonprofit Chapters and Affiliates, Key Legal Issues, Pitfalls, and Successful Strategies. While not every nonprofit has chapters and affiliates, many do, and many of our clients do. And as we know from working in this area for so many years, it's just an amazing hodgepodge of legal and political and other issues that come into play. We have a lot of experience in this area and hopefully have a lot of great things to impart to you in our program next month. And then in August, early August, on August 2nd, our program is going to be entitled How Nonprofits Can Raise Money and Awareness Through Promotional Campaigns Without Raising Legal Risks. Another very hot topic to nonprofits, to regulators, to businesses, and many others. And I think you'll find that to be a very interesting, dynamic topic as well. A few housekeeping points for today's program. Those of you here in the room have a booklet that has a printed version of the PowerPoint presentation along with quite a number of articles, probably more articles that we've written in this area than any other area. And we've excerpted a number of those in the back of your handout book there for you today. Of course, as many of you know, we have all of those articles and many more on our website, and these links are on the last page of the PowerPoint presentation, but venable.com/nonprofit/publications. If you search by topic area, you'll see a topic area for trademarks and copyrights, and you'll also see a topic area for social media. You can find all of our articles on these topics by searching under those two topic areas. This program, as I said, is being recorded like we do for all of our monthly programs, and those are all available on our website. If you or colleagues or others want to listen to those programs later, along with the streaming PowerPoint presentation, you can find those at venable.com/nonprofit/recordings. For this program specifically, an email will be sent to all of you, both in person and on the phone, tomorrow that will contain a link to that recording, and feel free to pass that on. As always, I want to thank my colleague in the marketing department, Jamie Fitzsimons, for her terrific help in putting these programs together. And without further ado, actually one other housekeeping point. Typically, we encourage questions throughout the program. For those of you on the telephone, do pose your questions to me throughout the program using the chat feature on the webinar. I'll have that laptop manned at the front of the room, and we'll pose those questions to our speakers at the appropriate times. For those of you in the room, because we have a really large amount of material to cover, and because I think a lot of your questions will be answered by subsequent portions of the presentation, we're going to pause. We're going to be covering, as the title suggests, 10 best practices. We're going to pause after number 5, take some questions, and then move on, but we want to make sure we get through all 10 today. We likely are going to go a little bit over the allotted stoppage time because of the late start. But we still want to get you out of here in relatively short order. So bear with us and save your questions for after best practice number 5 and then after best practice number 10. With that, I'm going to turn it over to Andrew to get us started. Andrew?
Jeff, thank you very much. It's just my absolute pleasure to be here today with two of the Venable partners I respect most, Jeff and AJ. I was reflecting, as Jeff was talking about, the long period of time in which we've been working together. And I've been serving the needs of Jeff's nonprofit clients in the trademark area. And I was thinking that, the 10 years ago or so that we started, this room would have been empty. And that's not really a joke at all. So when Jeff first came to me and I started helping nonprofits with trademark matters, I realized that really it was the forgotten group of trademark owners. The trademark lawyers who were doing things for nonprofits were doing them in a haphazard way. Really not a thoughtful way. And so we started many years ago trying to identify the themes in trademark law that apply to nonprofits and to really represent nonprofits in trademark matters more vigorously. And so as we go through these best practices, you'll see that we're going to I will cover trademark best practices, and we're going to alternate slides. So AJ is going to cover a number of other topics, but I will have what I think are the odd-numbered slides, and we will bounce back and forth between my trademark topics and AJ's trademark and other topics. And so the first best practice, of course, thinking back to years ago when trademarks were the forgotten asset of nonprofits, here we are today. What's best practice number 1? Understand the value of trademarks and brand protection. There's this terrific quote that I found, and it comes from an article that was very recent, and I encourage everyone in the room to try to get a copy of online. It's an article entitled "The Role of Brand in the Nonprofit Sector" from Stanford, spring 2012. The quote from World Wildlife Fund is, "Our brand is the single greatest asset that our network has, and it's what keeps everyone together." And I couldn't have said it better myself. You'll see another quote as we go later from this same report, but I absolutely love that quote. And when you think about trademarks and the value, of course, you want to start by identifying what is a trademark. There may be some in this room who really don't know exactly what it is, think that maybe it's a patent or a copyright, don't know the difference. So a trademark is very simply what you see every day. It's the brands that permeate the world. It's Diet Coke on the table in front of me. It's the acronym of many nonprofit organizations. It's the logo. It's the slogan. It can be a color. It can be a ringtone on a phone. It can be anything that identifies the source of goods and services that are being provided by the party who's providing those goods and services, whether that party be a nonprofit or for-profit organization. To really dumb it down, if you looked in the upper left-hand corner of your website, you'd see probably some of your most important trademarks. So I was thinking back again on the last many years and the changes in trademarks, and I thought it would be helpful to consider very quickly a couple changes over the years. One is what's happening on the National Mall. I grew up in Washington, D.C. I'm 43 years old now, when I was a child and through my early adult years, you would drive every day down Constitution Avenue past the National Mall, and there would always be an event, and you never really knew exactly, what the event was. You saw a lot of people, and then you read about it in the news or saw a story on the evening news. Today, you know instantly because everything is branded. The stage is branded. The T-shirts of the people on the mall are branded, so you know immediately, is this the Susan B. Komen For the Cure event? Is it any number of other things? So that is a dramatic difference which really demonstrates the importance of brands. Think about the people who are making decisions within legal departments and marketing departments in any organization today. It's what I call the ET generation. People my age grew up with the ET brand being thrown across Atari cassettes and Reese's Pieces and any number of things. So, people in my age group believe wholeheartedly in the power of brands, and so those are the people who are making decisions. Think also about Donald Trump and what he's doing now. When he started out, he was a real estate mogul. Now he's a licensee of a brand, Donald Trump. Think about what the legal world is telling us. When I started trademark law in '96, there were a couple thousand trademark lawyers from around the world that would go to the annual meeting of trademark lawyers called INTA. Today there were 10,000 in May at the recent meeting. Trademark applications are being filed in record numbers. The Trademark Association now has a group devoted to trademarks. And so I want to talk real briefly about this rise in trademark battles. Actually, the Wall Street Journal called me 2 years ago or a year ago for a quote that they ended up running in a front-page story about the rise in battles regarding trademarks among nonprofits. And so really the quote I gave, I think, says it all, which is basically the days are over when nonprofits would just say, we're all trying to do good here. Can't we all just get along? And, who cares if our brands are that close? We're all trying to again, do good. And so without commenting on the strength or weakness of any position here, this article talked about the Livestrong brand that everybody knows very well, and those policing efforts you'll hear. That's really by way of preview to something I'll talk about in a few minutes. The bet the nonprofit moment, think trademarks. What does this mean? Anytime you are launching a key brand as a nonprofit, whether it be the rebranding of the nonprofit overall, or a major initiative branding or rebranding, that's really a bet the nonprofit moment. When you ask consumers to buy into whatever goods and services you're offering under that initial brand, that's a bet the nonprofit moment, because if you're told through a cease and desist letter or a legal action that you can't use that brand, then you're really telling consumers that, hey, we broke our trust to you and we're going to be using another brand now. We now want you to buy into that. And so it's really an important moment because, again, if you think about back on the World Wildlife Fund quote, the brand is just so critical. So what is different about picking a trademark as opposed to picking a DBA or, legal name of the nonprofit that would be registered with a state? There's a dramatic difference that many people don't appreciate, and that's the legal standard that you're up against when you're trying to select and protect a trademark, and that is called the likelihood of confusion standard. That standard has a number of factors. It's a standard that's not applied when you go to register your DBA. It does consider things like the similarity of the goods and services, the similarity of the trademarks, the consumer group that will see the brands, and a number of other factors. This standard, I tell people, is incredibly low. It's really the polar opposite of the beyond a reasonable doubt standard, which is the highest standard under the law. You can win a trademark case with a survey that says that there is 20% confusion among consumers regarding a brand. And so the standard, again, is different. Consider the high cost of trademark litigation, which today averages $775,000. When you're faced with that type of cost, your only options typically are to move to a new brand or pay a licensing fee or buy the other side out. And other than that, you're really, again, at that bet the nonprofit moment where you have to decide, are you going to go to a new brand? AJ, I'll hand it over to you for best practice number 2.
Hi, everybody. I'm AJ Zatola, and welcome. In thinking about how to present these materials today, what we thought we would focus on is trademarks, obviously, because many of you will spend most of your prosecution dollars on trademarks in terms of trying to get them registered. But what about all the rest of the IP? The task sort of fallen to me to kind of identify all the other things that you might encounter on the IP front that could be forms of IP, but also things that are very much related to proprietary rights, data being one of them, or other types of contractual issues you will face in trying to protect your IP. So we're going to walk you through certain ideas and concepts to think about, starting first with identifying what those things would be, and then moving through perhaps auditing and considering how to manage your IP, and concluding with some discussion about how you might otherwise license. And I know many of you are social media people, so we will be discussing that as well. So in terms of identification, what are these other types of intellectual property rights to consider? Well, the first key one would be copyrights. What is a copyright? Well, it can be pretty much anything that constitutes an original work of authorship that's fixed in a tangible medium. These days, that tangible medium actually tends to be fairly intangible. It's closer to the mic. Sure. Probably hearing it. Things such as computer software, images that you see online, all of those reside at least somewhere on a magnetic disk. That disk itself is the tangible medium. With copyrights, there is no registration requirement for rights to be identified. Rights exist upon creation, and if there's a few key takeaways to come out of this presentation with, that's an important one to remember. But registration is possible. It affords the copyright owner a number of rights and, in particular, specific remedies unavailable to someone who has not registered. What a copyright does is it gives you certain positive rights that authorize other people to do certain things. It's 5 rights. Chief among them would be reproduction, distribution, and the opportunity to create derivative works. The other 2 are performance and display, and I'm not saying that that is impossible, but for nonprofits, these 3 tend to be the ones that we see more often. Moving on, trade secrets would be the next thing. And again, what can be a trade secret is fairly broad and varied. It can really be almost any type of information, but the information must have certain attributes, first of which is it can't be readily available. So if you're posting about it online, it's no longer a trade secret. If you have published it, it's no longer a trade secret. It is a right that you primarily create through maintaining its secrecy. What is not otherwise here is also an obligation or a condition that the information have at least some intrinsic value. As to what that means to everybody, well, it's very much subjective, and so the reason I haven't highlighted it is because you will decide for yourself as to whether or not it's valuable. As to whether a court of law thinks otherwise, you don't need to concern yourself with that until you get to a court of law to argue over this point. But with respect to trade secrets, again, the key takeaway here is it must be maintained in a manner that keeps it confidential. This is something that is typically viewed and assessed by the measures that you take to keep it secret. What kind of measures? Well, it can be almost anything. Most commonly, non-disclosure agreements, forms of non-compete, password protection on access, using firewalls to prevent access, making sure that people need to know or have other physical security measures or procedures on top of the information itself. And the final thing that isn't there is just don't tell anyone. A great example of that would be the Coca-Cola secret formula. Only 1 or 2 people within the company apparently know the full formula. It's otherwise not disclosed. Patents, very, very key. IP rights. Most nonprofits tend not to have any patents. I know the people online can't see this, but show of hands in the room, how many of you actually hold ownership rights in a patent? Raise your hand if you do. A few. So we'll talk about it briefly, but for this audience, this isn't really among the key IP rights. But what we're talking about here are ideas, but they're novel ideas and non-obvious ideas. It's a standard established by the Patent and Trademark Office. It doesn't apply to everything, meaning if you have thought of it before or reasonably think about it, you may not have an inventive idea that constitutes a patent right. This is a right you need to apply for. You don't have one simply by virtue of claiming it. It is territorial, meaning based by nation. It is a finite term, 20-year monopoly. time sensitive because, again, like trade secrets somewhat, if you start to publicize your idea, it may lose its patent significance. So if you ever have something you think is novel and non-obvious and qualify for patent protection, be careful about publishing it and disclosing it to others until you talk to a patent attorney to make sure you otherwise shouldn't be filing for a patent application. This is a right to exclude. Unlike some of the other forms of IP, it's not a positive right granting you a right to engage in something. It's a right to tell others to stop. The reason it's drafted this way is because this is the only IP right that extends to ideas instead of things. But it imparts a number of rights to you, but the process itself it's somewhat lengthy. It includes disclosures you need for getting assignment invention agreements from your inventors, etc. The final category is not something you're going to see written in a textbook, but it's something that I like to explain to people, captures everything else that is otherwise proprietary or will fall in the basket of technology. When you're thinking about IP, you're not always going to have the luxury of dealing specifically with a piece of IP in the form of a trademark or a patent. But you're all using technology today. You're all using proprietary assets. You're all using data. So I like to think about these things in terms of dependencies. We all depend on them. And so how do you think about what your dependencies are? How do you make sure that others think about what your dependencies are? Well, one way to think about it is, internally, what do you need to do or have to operate yourself? So there are internal dependencies. Contractual dependencies is a key one here. You need to license technology and IP rights from others, and they need to license these things from you. So these are contractual dependencies. Legal dependencies. Well, the law imparts limited rights in all forms of IP, both for yourselves and for others. And so thinking about what those limitations are is very, very key. I know a number of you are familiar with fair use, which is a topic in and of itself, but certainly that concept is a dependency because you're not seeking permission in that context. You're simply relying on the concept for the right to use or for someone else to use your property. And the final thing is market trends. What is the market allowing, disallowing? And that also is something to be aware of with respect to your space. What are nonprofits doing generally to forms of particular intangible assets?
Thanks, AJ. Thanks, AJ. Moving on to best practice number 3, back to trademarks. The theme here is move toward distinctive brands or trademarks. One of our clients, EASA, came to us a couple years ago with an idea for a new brand, Leading Age, and asked us to do the trademark searching and registration work that would be required to protect that brand. And my initial reaction was kind of to smile and think, what do they think they're up to here? The nonprofits all use acronyms as brands. And I realized at that moment that it was all really changing in the nonprofit world. And this was one of the kind of tipping point moments for me in my representation of nonprofits where I saw a nonprofit really thinking about branding in a new way. And I really applauded it. And it's done very well for the nonprofit. So take a look at this website and you look at the before and after. And many people would say, well, wait a minute, they had an acronym. The acronym represented the name of this aging organization, American Association of Homes and Services for the Aging. But they needed a new image. And it would seem somewhat odd to many people to pick something that really is more like a slogan, Leading Age. But as it turns out, by doing that, they create something that's incredibly memorable and therefore very powerful as a brand. Think about what we call, it's kind of a big phrase here, but the hierarchy of distinctiveness. In trademark law, this is kind of Trademarks 101. How do we organize how powerful brands are in terms of their strength? And if you think of this as a ladder and start on the bottom rung of the ladder, we have what are called generic terms. These are not trademarks at all. They could never be a trademark, at least not for the goods and services in the field that's obvious for those names. And so an example, of course, in our field here is nonprofit and association. Those are the common commercial terms that everybody uses to say that they are a nonprofit or association. Next up the ladder is something that is capable of being a protectable trademark over time and having some strength, but doesn't initially start that way. There was a recent decision that confirmed the fairly obvious point that Tennis Industry Association is descriptive and therefore not immediately capable of having trademark rights because it immediately tells consumers exactly what is being provided. This is an association in the field of the tennis industry. When we go next up the rung here, now we get to names or slogans that are immediately capable of being protected as trademarks, and this is kind of where you would like to be, here or above. A phrase or a word that's suggestive takes a moment of reflection to understand what it really means in the context of the goods and services, and so the example here is race for the cure. The reason that requires that kind of extra moment of reflection is because it's a double entendre by U.S. trademark law standards. It basically has a double meaning. Where you'd really love to be, if you could, would be arbitrary, like mensa, which is a Latin word or Italian word, I think, as well, that means table or cafeteria. Or ideally, to be something like Oxfam, totally made up, and you could make a case for something like Smithsonian fitting in that category as well, based on the name Smithson in the case of Smithsonian, but again, made up ultimately. Going to the next slide here.
Well, Andrew, before you move on, do you just want to talk for a second about what it means if you're higher up on that ladder in terms of your trademark rights, protectability, enforceability, et cetera?
Great question, Jeff. So the higher up you are on the ladder, the more ability you have right out of the box when you start using the brand to stop others from doing the same thing. The further you are down the brand, the harder that is to do. Over time, if your brand becomes strong, you can take a otherwise descriptive brand and create additional layers of protectability, have it protected as a trademark, but it will always still suffer somewhat from that fact that it had to acquire distinctiveness over time. There are all kinds of examples of marks that became very powerful and strong through that process, but generally, the higher you are when you start, the better you are in the long run. And so to make that point, I've got a couple slides here that come off an article that I wrote with a colleague of mine, and the article was called "The Trend in Top Brands, Use More Inventive Naming." So we looked at the 2012 Brand Finance Global 500 rankings, and we looked at the top rankings, and we wanted to see if there were any trends over the last few years as to whether the real top producing companies, and these are mostly for-profit companies to be fair, are using more distinctive names. And by that I mean higher up on the ladder to start. And what we found was, whereas in the old days there were 50% that fit in that real distinctive category of being fanciful or arbitrary, those top two rungs, today, or based on this recent report, there were 80%. And so that was definitely a notable change. So my second point there is just that superb brand management can, of course, help a inherently weaker trademark become stronger over time. But given today's hyper-competitive market, it really rewards brands that are more distinctive from the start. And to that point, compare some of these brands in that top 10. So today you've got Apple versus the old predecessor-type brand Wang, Google versus InfoSeek, Microsoft versus WebTV, Walmart versus Woolworth, Samsung and Vodafone versus Palm, Amazon versus B. Dalton. You can definitely see the trend. The better brands are inherently strong to start. There are exceptions to that rule, but this is a trend. Okay, so people will say, well, this is not possible. It's all great theory, but how is it even possible in the nonprofit world? And to that I would say it definitely is possible, and here's a great example of a brand that's been around for a fairly long period of time that's incredibly distinctive and therefore incredibly strong from the start and therefore has done very well over time, the Fishing School.
And before we finish this topic, Andrew, so if your brand is, if your trademark is stronger and if it's higher up on that rung, You indicated that it makes it earlier on, it makes it easier to enforce, and even later on, it gives it more strength in enforcement. Just to make sure our audience understands what that means, give us a couple of examples of, say, if you have this established brand and you've filed for federal trademark registration, which I know you're going to talk about later, and someone then 2 years down the road files and seeks a federal trademark registration for a similar name or that contains some of those similar words. Can you explain how the original nonprofit is in a stronger position if it had a stronger brand? Just trying to get the audience a sense of what this means.
Yeah, great question, and I definitely don't want to leave anything out here that's a critical point. We had a nonprofit client, as an example, that started with a descriptive brand, again, 2 rungs up of that ladder. And they were able ultimately to get a registration, to get trademark protection. That took 5 years, 5 years of use. And that's kind of the standard in the U.S. In terms of just kind of regular trademark use or regular use of a phrase to get to that 3rd rung, 5 years. Okay. During the next 5-year window, so years 6 through 10, you're still vulnerable to challenge on that issue of, hey, shouldn't you be on the 2nd rung? And so what a client would find in that period of time after they've, quote, secured trademark registration and trademark protection is that they're really still vulnerable to the same attack for the next 5 years. And so that's really how you could have a difference in that client's prospects for truly enforcing the brand with a client that started out on one of the higher rungs to start, where they wouldn't have any problems like that for the first 10 years.
So, and another way to put it is, this is for nonprofits. It's oftentimes a lot about trying to make sure that there are not other organizations, particularly in your space, and sometimes even outside your space, that are using similar names that could confuse the public as to who is the source of this nonprofit's products or services. And what Andrew's saying is both from a registration perspective, in terms of being able to deny others federal trademark registration for marks that may be somewhat similar or have some similar words in them, or even if it's just enforcement out there in the marketplace through cease and desist letters or litigation or otherwise. The stronger your trademark is, the easier it is to enforce and keep others from coming along with a similar name that could confuse the public or members of your industry or others as to who is the real nonprofit in your space. All right, let's move on to AJ for number 4.
So now we have identified all the major forms of intellectual property. So what would be the next step in your protection strategy? Well, the next step is figuring out what you have. It's sometimes amazing to us when we field questions. They're often specific to a particular situation or context, but at the heart of the matter is the basic point that the person asking the question sometimes doesn't even know what the organization claims to have as its own IP. So in terms of your protection strategy, we always recommend conducting an audit, and it's largely an internal audit, figuring out what you have, and starting with your own IP, but not necessarily stopping there, because many of you might be entitled to exploit and use IP of others and be sometimes responsible for its own protection, particularly in the dynamic of a local versus a national chapter organization. So define your IP portfolio. The key IP forms: patents, copyrights, trademarks, trade secrets. If you have a lot of IP and it's difficult to grab your hands around all of that, then one way we have found it easier to consider is to consider grouping IP into whether or not your use falls into some basic areas. Is it used primarily for technology purposes, in other words, to run or to operate your nonprofit? Is it something that you might otherwise need to exploit in order to do something else? This would be in the form of technology. And finally, does it have some type of income generation capability? Notwithstanding the term nonprofit, I frequently don't look at you as being any different from any for-profit commercial entity. And the notion of income generation doesn't have to be direct. That doesn't necessarily mean that you're charging a fee for use, but you could be exploiting the intellectual property in a way that leads to other fees. This is most commonly seen when you are distributing materials that are protected by copyright law for free, but as a part of some type of benefit or as a part of a program. So when you're thinking about these things and you're doing your audit, well, what aspects of IP should you be recording, keeping track of? On copyrights, focus on how the copyright was created? That's always the first question, because that date of creation and completion is very, very meaningful to determining the term for your copyright. Figure out who the author owner is, and we're going to come back on a few of these throughout the presentation, but this is critical on copyright, because by operation of law, the author is the owner, barring some other agreement or some other work-for-hire arrangement, which is also limited, and typically for you is going to be limited to either employer-employee relationship or some type of collective work where there is an understanding in advance that the contribution is for that collective work. Do you register your copyright? We talked about how it's not necessary for protection, but it does give you a number of benefits, and in particular is necessary for enforcement. Are you using a notice? Do you have the little C symbol with the publication date? Is the publication date accurate and up to date, or has it been left there for a number of years? And finally, who created? In your case, many times you're going to be assessing whether or not a contractor was utilized, because this is going to be typically how a lot of your electronic work, such as your website, gets created. Did you have them transfer to you ownership such that you are now the designated claimant and owner? Moving forward on trade secrets, again, this one's kind of easy. What steps are you taking to keep it secret? What measures are taken to limit disclosure? How are you handling both your new employees and your departing employees? Have you made sure that they have returned to you all of the things you regard as a trade secret? What is the physical embodiment of the trade secret? Where this comes into play sometimes is if you believe you have a unique methodology for something that is sort of a concept but is otherwise reflected in writing or in diagram form. What is the document, the physical embodiment of that trade secret? Because keeping track of that sometimes means you are keeping track and managing the disclosure of the trade secret idea. Do you have an internal policy? Many of you have handbooks. It's probably there for your employees to review, but if not, consider having something specific to trade secrets, which is otherwise known as your confidentiality policy. Finally, are you using a non-disclosure agreement when you need to disclose trade secrets? On patents, the key consideration here is it new? Could it be patentable? You probably are not going to be able to figure that out on your own. You will need to engage a patent attorney, but you want to at least have some process for managing that moment of invention, managing whether or not you can consider if it's a patent or not. Who was the inventor? Have they departed? This is a situation we encounter often where the inventor was someone who was working with you and no longer is, and you are going to need their assistance in the patent application process in order to proceed. Timing, again, we talked a little bit about how public disclosures can invalidate your patent rights, so to speak, and so you need to be careful about considering when something was invented and when it was then first published. And finally, talk to a patent attorney as soon as possible when you think you have something that's novel. Data. I brought out a separate slide for data because this is increasingly becoming more important as a type of proprietary asset. But in the United States, it is not separately identified as a form of intellectual property. It certainly can be covered by other types of IP, but a database of nonprofit members, employees, customers, clients, business relationship, etc., in and of itself isn't a separately recognized intellectual property right in the United States. But that doesn't mean it doesn't have tremendous value to you. So in terms of thinking about your data, you're not necessarily considering who created it, but you should start to consider who is claiming ownership in it. Do you regard the database of information as your own, or do you believe it belongs to someone else? In terms of new data that's being created through your website ventures, through your social media campaigns, who is claiming an ownership in that data? It's a question you need to start asking yourselves. For certain kinds of data, you need to be asking the question of how are you gaining access to it? How are you acquiring it? This is most easily seen with respect to personally identifiable information, where there are obviously privacy concerns. But where are you getting the data from? How is it coming to you? Did you need to do something else in order to comply with applicable law? Was it necessary to provide some type of notice as to the data collection? receive a consent from the data subject. Again, this is a generalization about all kinds of data, but you should begin to ask these questions about the data you deem meaningful, and finally begin to consider the manner in which you're using the data, because that is also going to be equally important in terms of whether or not other forms of IP can be used to further protect it. So if the data is aggregated in a unique way, you might be entitled to claim copyright protection. If the data is disclosed under limited circumstances where confidentiality is being maintained, you can treat it as a trade secret. But you are not going to be able to account for these things unless you first ask the question and consider how you're using it.
And AJ, before you get to your last slide on this, just to elaborate on one thing AJ just said, data is very important to many nonprofits in different ways, and then sometimes it's really the bread and butter, key intellectual property that nonprofits own. But as AJ alluded to, unless data is organized in some unique way, generally speaking, a lot of data, for instance, alphabetized lists of members or things like that, are not subject to copyright protection. So you can't rely on the copyright laws to protect that data. You have to rely on other sorts of protection. Perhaps it's a trade secret, or perhaps, as AJ is going to get to in the next slide, and more often, you need to protect it contractually. So anyone who is getting access to that data, could be vendors, could be members who are getting membership lists or other data. You want to protect that valuable data through contract, through agreements, in order to put limitations and restrictions on the use and disclosure and dissemination and ability to profit off of that data. Don't rely on the copyright laws in many instances.
Excellent point. And one of the things to keep in mind about copyrights is it doesn't cover everything. It doesn't cover an expression idea, only the sort of original expression. So facts and ideas are not entitled to copyright protection. If those facts and ideas are otherwise publicly known, they may not qualify for trade secret. And so when you're trying to protect your data, it's sometimes difficult to separately claim some interest in it. And so the manner in which you are handling, collecting, and disclosing the data, primarily through contract, is going to be the primary way you can protect, as opposed to claiming some separate interest under IP law and being able to claim some right to enforce in that manner. The final part about your IP audit, obviously, is you've got to look at your agreements, and there can be all different kinds. We've put a whole bunch up on the slide here of things to consider, but these agreements can be in many different shapes and forms over where the IP is being created, where it's coming from, how it's being licensed, how it's being disclosed to others, and you would need to consider all these things in thinking about your IP and putting together a listing of things that you claim as your own, because from there you can build a management program around protecting your IP.
All right, back to trademarks and best practice number 5, search and register trademarks and brands properly. We're going to talk about how you don't have to register a trademark, but there are tremendous benefits. But what you see right in front of you is the symbol that you want associated with any key trademark you have. That's the trademark registration symbol that's recognized internationally. Going to the next slide, the key point here is that the registry, or more precisely, the trademark registration, is king. Any dispute that you have will always come down first and foremost to who has the presumption of rights. If you've got a trademark registration in any country, that registration will give you a presumption of rights in that country. I have, at any given time, a number of disputes ongoing. One of them that's very significant right now for a client, where the client has the registration. In fact, its facts, show that presumption might be rebutted, but any number of lawyers has already looked at this case and concluded just on the surface that, hey, the client wins because it's got the registration. So what you find is that this is what you're going to want to have for multiple reasons. And one is, what are you going to do when you try to enforce this brand in social media? And the answer is, if you have the trademark registration, you can go to Facebook, you can go to YouTube, you can go to Pinterest, you can start a domain name arbitration proceeding before WIPO and ICANN based on that registration, again, giving you the presumption of rights. I've found probably in 10 cases in the last 6 months that where we've sent a simple email to Facebook or YouTube, for example, with the client's registration identified, that within 24 hours the thing that we complained about came down. And that timing can mean the difference between keeping the goodwill of your brand intact and letting someone else run with it without your permission. So who's registering trademarks and what's happening in the nonprofit world? I thought it would be really helpful to consider the trademark activity of nonprofits this year so far, about half of a year's worth of time, compared with this incredibly hot area of mobile phone apps. And so I took a look at just a real basic search here to see generally who's filing for mobile phone apps, and we've got about 1,000 new U.S. trademark applications in 2012. We know that's a hot area. No one would dispute it. So what's happening in the nonprofit world? Well, when you look for some of the classic, real bare-bones language that a nonprofit would use in trying to protect a trademark through the registration process, you find actually even more applications are being filed. And so again, the registry is key and the nonprofit area is hot. All right, so a couple kind of horror stories here, and literally these happen, I would say, every couple weeks in my nonprofit practice, and sometimes more often in the nonprofit practice than the for-profit practice. So I call this slide From Russia with Love, and I want to distinguish, and you'll see why in a moment, but I want to distinguish between a first-to-file country, which the U.S. is not. In the U.S., you don't have to file a trademark application to get some trademark rights. You can have what are called common law rights. But those are very, very hard to prove because you always have to have evidence of all your use and all your customers in every single geographic area all over the country, and nobody tends to have that evidence. So much better to have that presumption. In a number of foreign countries, they operate on a first-to-file basis, and so that means it doesn't matter what happened in terms of use. We don't care if you've used your trademark here for 10 years. If somebody else filed first, they're going to get the rights. Now, there are always exceptions to what I'm saying. You know, if you're a famous brand like Coke or Nike, you're going to be able to overcome these problems. But for your average for-profit or nonprofit client, it's not the case. And so with this case in Russia with this one client, we see something that we see occasionally for nonprofits with chapters, and that is the chapter of what I call goes rogue. They go out and they register the trademark in one of these first-to-file countries, and then they say, okay, well, we're going to use this leverage to get what we want to get out of the nonprofit because we're not really pleased with how we've been treated. We're over here in Russia. They're not showing us the love from the U.S., and so they hold up the registration. And in Russia, all they care about is what's on the piece of paper. So what that means for the nonprofit is an investment of a large amount of money to pay the lawyers to try to deal with it. And it's not just the Venable lawyers, it's the lawyers in Russia. So, and it's a very expensive and unpredictable process.
But of course, it's also a process that you and we have gone through a number of times now with some of our clients. One of our nonprofits in particular has been the most aggressive and expansive in terms of its international trademark registrations. They've certainly made a huge investment. It's actually a certification mark primarily that they're registering around the world because their certification program is kind of spreading like wildfire around the world, but they recognize it's so critical to protect that key intellectual property asset, the trademark. So it does cost a lot and takes a lot of time, and it's not easy, as Andrew said, but it's critically important because when you start operating your programs and activities and sharing your valuable intellectual property, of course protecting your copyrighted material is key, and that's a whole separate process, but protecting your trademark is absolutely key.
Very well said. And I would add to it, very well said, Jeff, I would add to it that we can certainly help in those situations. And in the case of that client with the Russian problem, we were able to get our Russian lawyers here into the office to meet with the client a couple weeks ago, and we have certainly a strategy for dealing with it, but it's just expensive and unpredictable. What is the trademark troll problem? Everybody's heard of patent trolls, where someone goes out and gets a patent, secures it for the sole purpose of extorting another party. That's now bleeding over into the trademark world. So we're seeing parties go out there, secure a trademark, maybe by assignment from another party for the sole purpose of using it against a nonprofit or a for-profit. They will identify that you have not applied to register your trademark in that country and that there may be an opportunity. So that's one issue, and I'm going to talk for a minute about another major problem that we're seeing even recently, and that's the what I call the opportunity and risk of joint ownership. So trademarks can be jointly owned. The problem is, what if you don't document the specific controls that will be in place once the divorce occurs, which is inevitable. It may not happen after a year, but it may happen after 10 years. And then what happens? And there's always one party who's going to have a bigger interest in the brand than the other. So I'm not going to comment too much on the issue other than that because I have an active case going on right now, but it's another area where unless you do things on the front end precisely, you will be spending a lot of money later.
Sorry to interrupt, Andrew, but be remiss, and it's something we'll certainly cover in our program next month on chapters and affiliates, but certainly one of the key provisions, the most key provisions in my opinion, in every affiliation agreement that you enter into with your state and local chapters domestically, with your international chapters and affiliates worldwide, is the trademark license provision that says this is our trademark, and typically you're going to cover copyrighted materials and other things too. But in the trademark area, this is our trademark. We're letting you use it because you're entering into this affiliation agreement with us. We're chartering you as a chapter, or we're licensing our IP for you to use to be our official designated affiliate in this particular country. But here's the conditions under which you can use this trademark. It has to be done in this style, in this manner. You have to get prior approval from us if you're going to use it in any different manner. You can't use it for XYZ purposes. And if you ever disaffiliate with us or otherwise breach this agreement, you recognize that you no longer have the right to use this trademark. Also, you don't have the right to go and register the trademark in that foreign country. That's reserved for our right. That's our right solely. Things like that are absolutely critical to include in your affiliation agreements.
I think we're going to ask Jeff to join the trademark group because he has a lot of passion for the area, which I certainly love and respect. So I've got two more quick slides. I know that we've got to move through these slides. We've got a lot of them, but two more quick ones on this subject that are both very important. One is kind of the nuances for nonprofits in terms of registration. One is, how do you register, or can you register one of those marks that's on the second rung of the ladder, a descriptive word or phrase? And the answer is you can do it on the supplemental register is what it's called. It's worth doing. We do it for many nonprofits. It provides certain benefits. It provides really minimal benefits other than the ability to use the Circle R, which does have an enforcement value, and the ability to really reserve a place for you on the preferred principal register. They tend not to have that option in foreign countries, so something to keep in mind. Really the key issue that I tend to see a lot lately, and Jeff mentioned certification programs, is this critical distinction between what is a certification mark, and that's a term of art in trademark law, versus an accreditation mark. And so in the nonprofit world, most nonprofits, whether they are, quote, certifying individuals or entities, will say, well, we have a certification mark. They really don't, probably 9 times out of 10. And so this is one of the key areas where years ago we identified just a trend in other law firms improperly really representing nonprofits and treating the certification, the quote certification programs, which really weren't, treating them as certification programs. So in general, what you will find, and there are exceptions, is that when you are, quote, certifying an individual, it's going to be really more of an accreditation program. When you are, quote, certifying an entity, it's really a certification mark by U.S. law standards. And so I'm going to skip over the next couple subjects, but as you know, what's hot right now just in terms of the marketplace, mobile apps, we mentioned earlier, social media services. Many nonprofits provide all this stuff. Have you registered your key brands for these goods and services? Again, outside of the U.S., we talked about Russia, but it's a good reminder that trademark law is on a country-by-country basis. And so there are really only a few exceptions. One is the European Community, where you can cover 27 countries in one filing. But generally, when you think of your brand, you've got to think of where you're using it for goods and services, and have you secured a registration, if for no other reason to avoid that first-to-file problem. There's something called the Madrid Protocol that I'll skip over for time, except to say that in general, and I was one of the first to file under the Madrid Protocol in the United States years ago. In general, my experience with it is you should forget about it and move on. But don't forget about China, because if you pay a little now, you can save yourself a lot later. That's really the choice. As I say on the slide, pay a little now or a lot later. It's totally true. That's the country to think about probably first and foremost when you think about your brand protection. Then there's the power of copyright registrations abroad. If you don't have a trademark registration, if you've missed that first to file opportunity, sometimes your copyright registration can save you.
Sorry, I think we have to keep going here in the interest of time. We will definitely save time at the end, though, for questions.
So moving on in the concept of how you are internally managing your IP, we've gone through your audit. You now have cataloged all your IP. So how do you protect it now? Well, protection, again, after you've audited, it really becomes a concept about management. And how do you manage your IP? Well, you should be creating your own policies for continuing to audit your IP, because IP is continually being created, particularly as it relates to copyrightable works. There's no one right way to do this, but you ought to have some recognized policy for how your organization approaches this. You want to be educating your personnel, your employees, about your IP management processes and how you are otherwise taking steps to capture IP, to identify IP, and maybe perhaps to protect it through some other measure. You want to be considering the available IP registration processes, certainly trademark, but as it relates to copyrights and patents, you can register copyrights. And as we mentioned before, it is the only way you can really enforce and file a suit for copyright infringement. But you may not necessarily want to be registering every single work that qualifies for copyright protection. That could be an infinite number of things. And so you ought to have a policy in place for considering what works you might want to separately identify for copyright registration. As it relates to patents, I mean, the question really becomes, is it novel, non-obvious? But you're not going to know that unless you have a policy for identifying instances when you might have created something along those lines. Finally, your policy really ought to be also incorporating a confidentiality obligation, not only for yourself and your employees, but also your contractors, your business partners, et cetera. When you're thinking about managing your IP, there's a couple key considerations, and some of these are recurring themes, but they're very, very important to mention. Do you own? Can you use? And do you own is critical in any protection issue, because you can't enforce if you don't actually own. And so you need to be thinking about first procuring ownership before you can move on to other instances where you might need to take action to enforce for acts of infringement or misappropriation. So capture your IP, starting with your employees. Yes, there is the work-for-hire doctrine, which by operation law will make you as an employer perhaps owner of what your employees are creating. But it's a limited doctrine, which means that in instances that fall out of that statutory limit, you are going to need to get an assignment. And also you need to make clear and consider that with your employees, your works and the things that you take ownership in are only going to be the things that fall within their scope of employment. If you have hired someone to perform janitorial services for you and they write your website, the two things may not correspond, in which case you may not necessarily have a right to the website. So in thinking about this issue, you also want to be giving consideration to the role of the employee and what they are doing for you. With consultants, we absolutely recommend that you have a written assignment agreement with all of them to, by writing, have conveyed to your organization ownership in your IP, and in particular copyright or anything that might constitute a patentable right. With founders, main executives, you need to do these things too, notwithstanding your higher title, and in particular because many times you might have more primary role in formation of some of the organizations. You need to make clear that IP that the organization is claiming an interest in is actually in the name of the organization. And don't forget about licenses of key technology that you yourself are exploiting. On that point, you also need to give thought to whether or not there are any restrictions. In your case, it would be quite common to see a restriction or a condition that your use is only for quote-unquote nonprofit purposes. And so when you're thinking about how you can use or how you're going to allow others to use, you want to be thinking about what conditions or restrictions in place. Is the license arrangement or other agreement exclusive? Does it include some type of non-compete about you not being able to act or use the IP outside of the nonprofit arena? Are there territorial limitations, United States only or a state only? Does it have some type of MFN most favored clause, meaning that the pricing of the licensing you offer someone or you receive, is it more beneficial or must it be more beneficial?
And AJ, let me interrupt for a second. This also includes not just your employees and your paid consultants, but it also includes volunteers. Nonprofits heavily rely on the intellectual property contributions of their volunteers, so this is absolutely no exception. If the volunteer is not an employee, then anything the volunteer writes, makes a video of, makes a recording of, or otherwise creates, that volunteer is going to own unless there's an assignment or license of that intellectual property, particularly the copyright, over to the nonprofit organization. So for your speakers and for your authors and for your board members and your key committee members that are creating copyrightable works, it's absolutely critical that you get something in writing from all of them at the outset of the process that either transfers ownership via an assignment or at least gives a broad, perhaps non-exclusive, perpetual, worldwide, irrevocable, royalty-free license to the nonprofit to be able to use that work in any way that you want in the future without having to go back to that volunteer. It's an easy step to do. It's a best practice in the nonprofit world. Many nonprofits do it, and it will avoid a lot of headaches for you down the road.
And keep in mind on that point, which is very, very important to remember when you leave here, is that designations of ownership are not enough. If the document merely says it is recognized that you are the owner, that in of itself is not going to be deemed as a sufficient conveyance. It must say, I hereby transfer, sign, convey to you ownership of this work or this idea or IP. That is what is necessary for that written assignment, and these are things that were taken from the real estate world in terms of how deeds to property were transferred. Moving on our IP management focus, as we mentioned, you're constantly creating new IP. Well, your IP issues in terms of management are never going to go away. Things to be thinking about as you're managing are, international versus national, local versus state. Should it be confidential? Will it be public? These are things that are going to impact your IP protection strategies. How are you going to exploit? Are you planning on licensing it? Is it something you plan to sell? On the distinction in patents and trademarks, it somewhat times gets back to the point of, is it going to be public versus confidential? The quid pro quo for the patent right in the United States is you must disclose all your claims and how they are created. Sometimes it is better to maintain things as a trade secret, because so long as you are taking steps to maintain your information as a trade secret, it can be maintained in perpetuity, whereas a patent will expire. Copyright registration versus trade secret is sort of the same concept. In order to be entitled to a registration for a copyright, you must deposit a full copy of your work. With respect to programming code for software, a lot of times folks do not want to disclose all of the source code. And so that is a careful consideration needs to be made when you decide to register. For things that are otherwise published and generally made available, less of a concern, but these are things you're going to have to manage. You're going to need to start looking out for invasions or violations or infringements of your IP rights, because if you don't know, you're not going to be in a position to take action. Don't ignore IP claims that are made against you. If you receive a letter, we talked a little bit about trolls, you can't stick that in a drawer somewhere and hope it goes away. Sometimes that letter can constitute notice, which would give rise to higher claims for damages. And so if you receive these things, they need to be taken seriously, and you might need to talk to an attorney about that, or in fact you should. Information security best practices, this is becoming more important to more and more entities as data becomes more important and privacy concerns take center stage. You should be taking steps to maintain your data in a secure fashion. That means you can't just leave it out there for anybody to access. Your computer hardware and equipment and software should have limits on access, firewalls, etc. Because the laws involving data use and, frankly, circumvention laws that speak to acts that get around these protection measures are only going to increase as time goes on. Finally, in your management and considering other risks, what are some things to sort of target when you're looking at this? Well, clearly your website, your social media pages, as we're going to get to as a final point. Defects in record title, Andrew will definitely pull his hair out if the renewal comes up and you have not
changed the name of the owner if your organization has gone from one name to another. So it's important to make sure that your registered property stays current with your name. Threats to validity enforcement, a little bit of a prior point about making sure that you're considering other people's actions vis-a-vis violating your rights and, receipt of claims yourself. Unfiled inventions with pending application, this is the patent concept. If you have published something that could be patentable, make sure that you are taking steps to get it filed, or at least you talk to an attorney about it, because you could lose rights. Potential litigation, make sure you are acting upon this because you don't want to suffer a default judgment, and we're going a little bit fast here. Obviously, you can ask questions later. Security interests on your IP. If you have a credit facility, this is something you need to keep in mind because people can take ownership in your IP just through loaning you money. Software licenses, data licenses, content licenses, all of you make materials available. You ought to be granting those under a written agreement. We'll talk about that next. Strategic partnerships. I know all of you sing Kumbaya because under the banner of nonprofit, there are never any problems with your business partners or local chapters, but the reality is that you need to be dealing with them at arm's length when it comes to your intellectual property. And finally, certainly antitrust concerns, which could be a separate topic.
All right, moving on to best practice number 7. And so we'll go through the next 4 best practices, hopefully at 5 minutes or less, so we'll have time for questions here. Let's see if we can do it. So the key thing here is it's licensing. It's a critical issue for nonprofits. It's why it's a standalone topic. If you think about maintaining brand strength, why do you want to do it? What's the background for enforcing and licensing a brand? Another great quote, as I mentioned I'd have earlier from this Stanford review, having a strong brand establishes a kind of parity between a nonprofit and the companies they want to influence. Again, I couldn't have said it better myself, and so I won't. Enforcing trademarks, you've got to use the right trademark notices, a TM or an SM, it doesn't matter, whatever you want when it's not registered. Use the Circle R when it's registered. You absolutely are required to police your trademark. You can't just kind of say we have a brand and we don't care who else uses it. You're legally required to make sure that infringers don't infringe.
And of course, you can jeopardize those rights if you fail to do so. And you wrote an article a couple years ago about a nonprofit that lost its rights for failure to enforce them.
A great segue into a couple slides here coming up on that subject in just a minute. So I wanted to get to this very interesting slide about the top trademark bullies. This is a recent study of who's the most demanding in terms of policing, and I was really interested and impressed to see that there are 2 nonprofits on this list, 2 out of 10. And I can tell you that one of our clients has heard from one of these 2 parties in the last month. So it's something to consider, the Lance Armstrong Foundation and Blue Cross Blue Shield here. When policing goes bad, a nonprofit, this generally wouldn't happen, but it's a good one-off story that everybody in the for-profit world is talking about. When you get too aggressive with policing, in this world of social media, the party, if you've overreached your bounds, can try to reach out to others who may share your view and start a revolt against your organization. And so this happened with Chick-fil-A, who sent a demand letter to this guy who was printing T-shirts that said, eat more kale. And Chick-fil-A said, well, we own the brand Eat More Chicken. You can't do this. And Chick-fil-A was unrelenting. And this guy waged a social media war against Chick-fil-A and was very successful, and everybody in the trademark world is talking about the success of that social media effort. So what is the power of licensing? Now, shifting from kind of general enforcement to the licensing of trademarks. It's obvious if you looked at what this, quote, trademark bully Livestrong has done. They've got separate websites, or at least one separate website that through a licensing arrangement is using the trademark of the Lance Armstrong Foundation for a spin-off group of goods and services. So naked licensing. Jeff mentioned that I wrote this article called Don't Get Caught Naked licensing. And so the article got a lot of attention. I hope it was for more than just the title, but I have to say I love the title. And so naked licensing is really a real phrase in the trademark world, and it's something that you truly have to avoid. There was this case where a nonprofit called Free Cycle that was engaged in the good cause of letting people recycle goods that they used, whether it be a computer or something else, rather than just sending it off to be broken into pieces and sold for scrap. They had this process where maybe there's somebody, it will be someone else's treasure to use that computer as it was. So the concept of free cycling. In effect, the nonprofit had chapters around who were using this brand without any control whatsoever. They just figured, okay, it's all good, who cares? Ultimately, they lost the brand. And so it's important to avoid certain failures that were evident in that case, the failure to retain control over use of the trademark by others, the failure to exercise actual control, not just written control, but to actually have actual control, and the failure to correctly delegate any kind of control to another party who might control on your behalf. And there's the slide with the failures to avoid. Skipping ahead to the four-step strategy to protect your trademarks in a licensing scenario. I've come up with these four steps that, to me are fairly obvious, but a lot of nonprofits are not following them, even after the article. The first step is to make sure that the trademarks that are used by chapters and members are treated as collective membership marks. We don't have time for a lot on that subject, but it's kind of an easy workaround to solve the problem. You're just basically saying, this is a logo that you as members and chapters can use, and we're going to register it as a collective membership mark, which basically means it's a mark that says you're a member of our organization. The licensing requirements in that scenario are lessened, and so that's why that strategy is helpful. A key thing to do is to change your policies. Jeff favors doing it in the policies over the bylaws to include a trademark license, and it literally can be a page and a half worth of language, and we've done it for a number of nonprofits, so that there are written controls in place. And then also enforce these actual controls. You have to actually do it. And then to the extent you have any members that are using a brand of yours outside of the normal routine of saying they're a member, but maybe providing some other goods and services that you approve of, make sure you have a separate freestanding trademark license in place for that. And same with non-members and chapters.
And just one quick aside to that. What Andrew's referring to in terms of having a trademark license to members and where you include that, bylaws, this is of course for nonprofits that have members, bylaws are deemed by law to be a binding contract between the nonprofit or association and the members. And so whatever provisions you include in those bylaws, you can write things that will then be binding, such as the license that you provide to a member to use the association's trademark. But in terms of putting all the very specific details about that license in the bylaws, we typically don't recommend doing that, and rather recommend cross-referencing, having something in the bylaws that makes that license binding on the members, but then cross-referencing something, say, in a policies and procedures manual or elsewhere that could readily and more easily be updated by the association.
Moving on and continuing with the topic of licensing, licenses are going to be one of the best ways for you to protect and enforce your rights, because it will define for your user base the conditions under which you're going to let people use everything that you're making available to them. Your materials have a checklist of things which are primarily there to tell you two things. One is, what am I licensing? And second, under what conditions? This is not exhaustive, but it's very, very helpful for you to begin to think about the conditions under which IP is being made available. And the other thing to keep in mind here is get it in writing. Don't rely on handshakes or writing it down on a napkin, because that written record will be very, very helpful if you ever need to enforce. It entitles you to not only seek claims for IP violations, but also for breach of contract. Many of you now are beginning to make your IP available online, so some takeaways on the notion of what a written agreement means electronically. Well, first of all, electronic contracts can be made enforceable. Second, that you need to be mindful about how to make them enforceable. It's generally a three-part process where you're providing notice, an opportunity to review and reject, and then there's some action be taken to manifest assent. Ideally, you want to receive some action from your other contracting party, most typically seen with an I agree, but sometimes other things can constitute acceptance. These are things you need to have in place in order to make your electronic contracts available. I would encourage all of you to have something along these lines with respect to any materials you're making available online, even if you're not charging a fee for it. Have a record-keeping process where when people are agreeing to these documents, it is very easy to do. Your web providers will be able to help you with this. And don't just rely on notice. I know a number of you make use of some type of disclaimer or terms of use. That is helpful in terms of providing notice. It sometimes can be helpful in terms of enforcing certain positions legally, but it is not always going to be enforceable as a contract.
Okay, we're moving on to the final best practice for trademarks. Make the big picture decisions on brands and trademarks now. And really, now that we've gotten into some of the details with licensing and other things, it's important to back off and say, where are we going as a nonprofit in terms of our brands and our trademarks and brand protection? Be prepared is really the theme here. Audit, as AJ pointed out very well, and consolidate your trademark portfolio. Many nonprofits have relatively small trademark portfolios that are managed by multiple law firms, and therefore, each of these law firms with one or two trademark registrations probably doesn't even remember that the nonprofit is a client. And so, inconsistency in terms of trademark registration management is a problem we see. Identify some simple things here: the key trademarks to your organization, the key goods and services that you're providing under those trademarks, and the key countries in which you're providing them. If you can make those decisions, the trademark lawyer can make every other decision a lot more easily. Establish a budget of some sort. You would be surprised how many nonprofits have zero budget for trademarks, and yet this is the legal, the aspect of the law that will protect that brand that is the essence in many ways of the nonprofit. Bridge the gap between legal and marketing. I won't go into that. There may be an article on that subject in some of the materials. And establish your organization's philosophy in terms of a couple things we talked about today. One is how aggressive to be in policing. Do you want to be known as a trademark bully? There are benefits to doing it. There are disadvantages. The benefit is that you let everybody know, stay away from my brand. That's not necessarily right for every organization. But still make a decision, how are we going to police this brand? And what's our tolerance for risk as an organization? This slide is a little bit old-looking. I was realizing as I stuck it in from one of my earlier PowerPoints years ago, but it's still a funny one that says we've considered every potential risk except the risks of avoiding all risks. Well, in the trademark world, whether you're searching trademarks or moving forward with a new brand, doing licensing or policing, there's always risk. Trademark law is full of gray, and if you can have some comfort level to accept that there's gray inherently within the field of trademark law, you'll do much better as an individual and organization dealing with it. Finally, I would say that this is a subject we talk about a lot, which is the risk of being your own trademark lawyer. These online websites, what we call trademark mills, and others, I won't name any, make it look so easy. Just pay a few $100s and get your trademark, and all you have to do is click here. As I think you've seen today, because literally we've just scratched the surface of many big issues, there are a lot of things for somebody with a lot of background to consider in dictating or suggesting the course of action for protecting the trademarks of a nonprofit, and you will be always much better served, just as you would to have a lawyer argue your case in court, to not do it yourself. So a properly searched and filed trademark is truly the foundation, and that's the key word, of a successful trademark and brand protection program. You can avoid long-term damage and cost by taking the right steps at the front end.
The final point is on social media. And, the key takeaway from this is even though it's a new platform that all of you are now utilizing to communicate, the issues that we've been going over sort of remain the same. You know what they are right now, but in terms of things to be thinking about, seek permission, seek permission, seek permission. I've said it 3 times. Just because it's easy to put up online doesn't mean you're entitled to use it. This goes for trademarks, copyrights in particular. Be careful about whenever there's any kind of commercial context. The nonprofit banner is merely more of a tax distinction. It is not a defense in an IP lawsuit. Be very careful about using other trademarks, and so, if you are considering a new one or even for an account name, don't be afraid to do a search. Be mindful of copyright ownership, which means that in these new social media environments, you may be creating copyrightable works. And so give thought to whether or not you need to be accounting for that creation and thus perhaps your right to or ownership in what is being created. Work for hire probably is going to be covering this, and so you need to have an assignment. A lot of times prepare for entities that want to use social media to collect information, and they're great for that, some type of set of contribution agreement terms for this purpose. In terms of protecting your own rights, monitor for misuse is really the best way to manage this, because getting out in front of problems is the easiest way to handle them. Don't be afraid to do a search online under your names, under your important materials to see if anyone's using them or using something similar. But when you need to take action, we talked about the instance where someone was overly aggressive, and certainly within the social media network, this can be a real issue sometimes. So balance. Sometimes it's somebody who's innocent. It may even be just simply the distinction between the national and local chapter. You don't have to be coming in all guns blazing. And what can be helpful here is clear notices identifying your IP for folks, and even setting forth some basic terms like limited right to use or all rights reserved to make clear that there are limitations on use. All of the major social media network providers have mechanisms for you to deal with IP claims if you need to do them. We had an instance really recently where somebody was complaining about a Twitter handle that happened to be too similar to their own name. Some of these account names are done on a first-come, first-served basis. Having IP protection in the form of a registration will better enable you to take action under these policies. If you don't have a registration, sometimes that might be a limited opportunity for you to use that. So that's yet another reason to consider registration for your important IP. Registration here, not just IP. If you have important trademarks, domain names, etc., within these social media environments, don't be afraid to go out and register them in your name. It is a first-come, first-served process subject to dispute resolution policies. Other things to give thought to in terms of social media, the network operator's policies are not there to protect you. They're there to protect the operator of the network. Don't assume that Facebook's or MySpace's or LinkedIn's policies are going to do anything for you. They're really there for their own protection, and so sometimes it's necessary for you to establish your own policy and terms for others within your own page. But don't ignore these policies, because within these larger networks, you are operating on their space, not the other way around. Manage your IP presence here. One of the things to keep in mind is you need to make your presence known. If there are other people that have a similar name or operate within a similar space, it is very helpful to identify what is your official presence or page or account so that you can then later distinguish yourself from others. And this is also helpful in terms of enforcement, where if things are taken from your page in the form of a download, etc., it is easier for you to trace steps and identify the context in which they were taken if you make it clear to the public and the network environment that this is your page. Consider your level of monitoring. How long should you keep things online? Sometimes it's there in perpetuity. Sometimes it's best not to do it that way. Give careful consideration to those collaborative arrangements that you're thinking about. Publish best practices internally and externally for your folks. This is not just an employee issue. A lot of times it has to do with how your IP is being used online. An important part here is, are they disclosing things that you consider to be a trade secret? Finally, understand that there are going to be limits on not only your own acceptable use, but there ought to be limits on everyone else's. Went over the checklist about how you should identify what's being licensed under what conditions. Don't be afraid to put similar terms up in a social media page. And finally, communicate your policy. Let it be known. I'm advocating these days the one-size-fits-all approach. So if you have a website terms and conditions, it's okay to start to incorporate those same wording into a website or a web page that's found in the social media environment, because sometimes the circumstances are almost identical. You don't need to reinvent the wheel over this.
And one final thing to add to that with respect to social media use policies, particularly for employees. Just this week, the National Labor Relations Board updated its guidance document on what are kind of acceptable and unacceptable provisions to include in social media usage policies for employees. This applies to all employers, unionized and particularly non-unionized employers. Has to do with the right of employees to get together and communicate in connection with potential unionization of your workforce. And it's very critical that you make sure that you don't have provisions in your social media policies that would run afoul of the NLRB's restrictions in this area, because they do have the enforcement right to bring an action against even a non-unionized employer. Okay, with that, it's a little up to 2 o'clock. We tried to, I think, deal with everyone's questions on the webinar during the course of the webinar, so I think I've answered theirs. But for those of you in the room, let's stick around and take a few questions, and then we'll stay after if you have more. Yep.
Yeah, so I have a question. It's actually two related questions about assignment agreements. And so in the case of a consultant, does there have to be magic words in there with regard to the assignment of, let's say, copyrightable work, or is it sufficient to say that we recognize that this is a work for hire? And let me just ask the other related question further to Jeff's point.
Wait, hold on. Let AJ answer that one first.
The question is, should there be some magic wording within any kind of agreement where you need to have an assignment of IP rights? And to your point about, is it enough to say this is work for hire? The answer to that question is no. Frankly, with a consultant, it is going to be rare in a lot of your context that is in fact a work for hire scenario. And so you need to have in there express wording that says that the consultant is assigning to you, and be mindful of whether or not you're using words like he or she is hereby assigning or signing at some later date. There's no magic way you have to say that. What courts will look for is that both parties be identified and there be some verb constituting a transfer event, but you need to have that wording in there to have a valid assignment.
One more thing. By the way, it was the Stanford case when they lost. And then to Jeff's point about the volunteers, or let me say also interns, so you have some kind of assignment agreement, and let's say it looks like something that a normal employee would have. But isn't there failure of consideration if they're just an employee, if they're just a volunteer or an intern? Don't you need some kind of consideration to make that assignment?
Well, the question has to do with if it's a volunteer and someone's making an assignment, whether it's, say, an intern, a committee member, a board member, et cetera. In fact, we had a similar question from someone on the webinar. Is that sufficient if there's no consideration? And you're exactly right. Any binding contract under standards of contract law has to have consideration for it to be a valid contract. And that's why you'll see in, for instance, our model copyright assignment forms for volunteers of nonprofits will have something in there at the beginning that says, in consideration of the right to serve in this committee, or in consideration of the right to fulfill this internship at the nonprofit, or in consideration of the right to serve on the board, the volunteer hereby assigns the copyrights and all of their works that they'll be creating to the nonprofit organization.
That's adequate consideration?
It will be deemed sufficient value so long as it's understood by the parties that was what the value is going to be. Another thing that can be used in that setting for what constitutes something valuable is, use of our materials. They would probably not have created something that is related to your organization had you not made your materials first available. And so most courts will not get in the middle of arguing over whether or not it was sufficiently valued, but they're going to be looking for whether or not there was something of value that was at issue.
So you wouldn't need some kind of, let's say it's a student volunteer, as distinguished from a board member, there would be some modicum of pay or...
That's a traditional licensing model. Well, people will put in some nominal amount for here's $1, here's $10. You can do that too, but that's sort of adding to the value equation. So it's not just the use of materials or the opportunity to serve or participate, but you also get $1. And so it's just adding to the value, and that's sort of bolstering the argument that it was valuable.
But that's rarely done in the nonprofit world. Yeah, in the back.
A corporate name that's copyrighted, that
Let me take that first. The question is, if an organization's name is, you had said subject to copyright registration, and has been for some time, should you also seek a trademark registration? It's one of the most commonly confused things that I've always seen in the nonprofit world with respect to intellectual property, and that's the distinction between copyrights and trademarks. And even after a close to 2-hour session here, I know there's still confusion between the two because, for instance, the same, let's take a nonprofit logo. You want to go to the slide that has some toward the end, yeah. Some of the nonprofits that we work with in the trademark area. It's further back. All of those are logos. Those logos are subject to both copyright protection and trademark protection. All of those particular clients, it's near the end of the PowerPoint, all of those logos are subject to federal trademark registration, which protects or gives the trademark owner an exclusive right to utilize that logo and prohibits others from utilizing the same or similar logo in a way that could be confusing to the general public. But because it's a unique expression of an idea, most of these, if not all of these logos, are also subject to copyright protection. Now, frequently, nonprofits don't think to register their logos with the U.S. Copyright Office for copyright protection, but it's not a bad idea, especially because copyright registration is such an easy and inexpensive process, at least vis-a-vis trademark registration. And it does give you additional protections that are really separate and distinct from the protections that come from trademark registration.
So it's stronger to be trademarked, is that what you're saying?
Well, typically the type of protection that you want when it comes to a name or logo, the most important protection is the trademark protection, without question. Copyright protection may be an additional benefit, copyright registration, in certain contexts, and it's not a bad idea to do so. Maybe AJ, can you think of instances where getting a copyright registration for your logo could give you some added benefit?
Registration is going to serve two primary purposes. One is it's going to be definitive evidence that you actually own this piece of IP, and for a lot of these intangible things, that's going to be very, very valuable. The second thing is it's going to entitle you to have certain remedies available to you that you wouldn't have without the registration. And that's going to apply both to a trademark and to a copyright. The distinction between the two can sometimes be confusing, particularly when you see things like this. Andrew will speak a little bit more to this, but think about the copyright as protecting this work of art. And that's really just the basic design that you see and the right to reproduce that. The trademark is going to protect the broader concept of the goodwill that is attached to the provider, the source of the goods and services.
Yeah, that's very well said. And all I would add to it is that the copyright registration in my world as a trademark lawyer can be most valuable in foreign countries when you're in one of those first-to-file situations where maybe somebody else filed first. If you could show that you had copyright rights that were had a date of creation that were earlier than the other side's filing date in that foreign country, that's when that can come into play.
A final point about registration, they are proving to be very valuable in other enforcement mechanisms. So you may not necessarily need one to prove ownership, and you may have no plans to sue anybody. But if you ever needed to enforce rights under the dispute resolution policy for a domain name, take advantage of a takedown policy from Facebook or Twitter, file abroad for trademark protection in another country, it is going to be a lot easier or only possible with a registration in the United States. The Twitter example, I think, is a very real one for all of you. Their trademark takedown policy will not recognize common law rights. It doesn't matter if those rights are indisputable. It's been around for 100 years. They just respond to, again, that pure evidence of ownership, which is the certificate itself. And so that is sort of an ancillary benefit we are now seeing with having registrations that you didn't previously have, because a lot of times people thought about the registration as, oh, I only need this if I'm going to sue, and I have no plans to sue. But you really need it now for these other sort of more informal enforcement mechanisms.
In a 2-second addition, and we'll take more questions, is that it's the U.S. copyright registration which can be helpful in those foreign trademark disputes, which is a very interesting twist on the fact that most countries have country-by-country law in the trademark world. Is a little different in copyright. Some more questions?
Yeah, up front here.
I have a question about the international filings of our trademarks. We primarily do business in the U.S. and Canada, provide services. But so in a first-to-file country, if you just file your trademark in that country, can you still enforce it if you're not using it in that country?
Yes. So the question is, for a party that has trademark use in the U.S. and Canada, but may want to protect that brand in certain other countries where there's a, say, first-to-file requirement, do you have to have use to be able to enforce that brand? And the answer is no, during a certain window of time. And so generally it's 3 to 5 years before you're subject to non-use cancellation. And so, for example, in the European community where there's a 5-year window, you can literally sue somebody with your trademark registration without having any use in place and win.
Yeah, but over here, one last question, then we're going to wrap up.
photography credit. So, for example, the membership organization and members serve on committees, newsletter committee, whatever. Photos are taken and put together in a newsletter distributed without a credit. And the organization says, you're a member, this is your committee, we have this policy written, you don't get a photo credit. Is the organization safe that way, or are they in jeopardy when that person comes and say no?
AJ, before you answer that, let me just take the liberty of broadening the question a bit, because this is a very common question we get. And I'm going to ask you to distinguish between copyright rights with respect to photographs, or we could say videos as well, versus the right of privacy and the right of publicity. Because we constantly see confusion in the nonprofit world. Say, a nonprofit's holding a conference and they take photographs and videos at the conference like it's typical, and then they'll put those on the website and they'll put them in next year's conference brochure and other promotional emails that go out and things like that. You have the issue of who owns the copyright in the photos and the videos that are taken, and I think that question should have been well answered by you previously, in that the photographer or the videographer is the owner unless he or she has assigned the rights over to the nonprofit organization through the written contract, which hopefully was done. Oftentimes is not, especially if the photographer is the husband of the senior vice president who happens to be doing it on the side. But then you have the question of, typically we're not dealing with the right of publicity, which deals with famous people, but the right of privacy that folks have. And a lot of nonprofits will try to deal with that issue by having, as say, part of the registration form, and maybe also part of signage when people walk into a room, that by entering this room or by signing this registration form, you hereby give us the right to utilize your image and your likeness in any promotional materials in the future without your consent. Maybe I just answered the question, but any other kind of context you want to add to that?
The distinction to keep aware of then is also the rights in the photograph itself versus the rights in the subject matter of the photograph, what the photograph is depicting. The photograph, again, it's owned by the person who took the photograph until that right is transferred. In terms of the subject matter inside of it, there's sort of two things to be aware of, and one is sort of captured by the right of publicity. The other is captured in the United States by the notion of really invasion of privacy. On publicity, it's really only recognized in several states and really with respect to famous people, but essentially there are limits on your ability to exploit a person's likeness for commercial reasons. And so if you are dealing particularly with a celebrity, they are at one of your events, you take a picture of them, you might own the photograph, but you may not have the right to use their likeness. For the rest of us who are not famous, the United States actually doesn't entitle anyone to some true right of privacy. You can take pictures of people, and it's not going to violate a law, even if that sounds like it's somehow morally objectionable. But what you cannot do is take pictures of people and use it in a way that invades their privacy. So if it's a picture of them engaging in something that they would otherwise deem sensitive, they don't want the public to know, you publish that photo, you will have invaded their privacy rights. If the photo depicts something that is false, you may have invaded their privacy rights. The claim is something different. But really the point there is that sometimes the depiction of the action itself can be a problem. But at the end of the day, taking pictures of people, even if we recommend releases, and we do that to make your lives easier, there really is nothing inherently wrong in the United States. And if you have a problem with that, you have to talk to your congressman about it.
Okay, I want to thank AJ and Andrew for a terrific presentation. Like I said earlier, the slides, as well as all of the handout materials, including the articles and whatnot, will be emailed out to everyone tomorrow, along with a link to the recording and streaming PowerPoint presentation, which will be on our website. Thank you again very much for joining us, and have a great rest of your day.